Well, good morning. This is your Kelso Report for Tuesday, August 7th, and I'm your host, Clark Kelso. We begin with a case that has facts that will be perfect for a first-year torts exam. The Ninth Circuit in McCone v. Simon Property Group was presented with a negligence claim against the owners of a mall where a third party had engaged in an 8-minute shooting rampage. The plaintiff had been shot and injured by the third party. Well, this fact pattern, of course, raises the question of whether the scope of the mall owner's duty extends to protecting customers against criminal conduct committed by third parties. Now, one approach by the courts has been to limit the duty to cases where there had been a similar act of violence on the premises. This is something like a one-bite or one-crime rule. Once there's been a serious enough similar assault, then a duty exists. Another approach has been to permit plaintiffs to demonstrate foreseeability through other types of evidence. It doesn't have to be a similar or same type of crime. The Ninth Circuit certified to the Washington Supreme Court several questions that will give that court the opportunity to clarify Washington law on these issues and to choose between the available alternative theories for creating a duty. We'll see what the Washington Supreme Court does. Next, the habeas case. The petitioner had been convicted of multiple counts of sexual assault of his on-again, off-again girlfriend of 10 years. He denied that the assaults occurred, claiming that the sex had been consensual. The trial court refused to permit the petitioner to introduce any evidence that the victim had made false claims against him in the past, alleging physical or sexual assault, and also prevented the petitioner from cross-examining the victim about her prior acts of prostitution. The Ninth Circuit majority held that the exclusions violated his right to present a defense, and that the state court's conclusion to the contrary was an unreasonable application of clearly established federal law. Judge Goodwin dissented on the ground that the petitioner had procedurally defaulted under state law by failing to notify the court in advance of his intention to introduce this type of evidence, so the court could conduct an appropriate hearing under state law to balance the competing interests. It does in fact appear that the defendant failed to follow the proper state law procedure. So we'll see if the United States Supreme Court takes this case up for a quick reversal. Next workers' compensation case, the plaintiff in Matthews v. NFL Management Council had played professional football for 19 years. When he retired in 2002, he was employed with the Tennessee Titans. 6 years later, he filed a workers' compensation claim in, of all places, California, alleging that he suffered pain and disability from injuries incurred during his career as a professional football player. In addition to the fact that he did not allege any particular injury as having occurred in California or any other California nexus, his employment agreement had a Tennessee forum selection clause. The choice of law issue was referred to arbitration pursuant to the agreement, and the arbitrator concluded that he could not seek workers' comp benefits under California law. The Ninth Circuit affirmed the district court's refusal to vacate the arbitration award, holding that he had not alleged sufficient contacts with California to show that his workers' comp claim comes within the scope of California's workers' compensation regime. You don't get to invoke California law just because you find its provisions to be favorable to your case. Next, the search and seizure case in United States v. Pineda Moreno. The Ninth Circuit had to decide whether to apply retroactively the Supreme Court's recent decision in United States v. Jones, where the court held this last term that the use of GPS devices to track a car constituted a search subject to the Fourth Amendment. The test for retroactive application under the Supreme Court's decision in Davis v. United States, 2011 case, is whether the law enforcement agents acted in objectively reasonable reliance on binding precedent when they attached and used the GPS devices. The Ninth Circuit panel held that as of 2007, when the GPS devices were attached in this case, Circuit precedent held that placing an electronic tracking device on the undercarriage of a car was neither a search nor a seizure under the Fourth Amendment, and so the agents acted in objectively reasonable reliance on that binding precedent, and the defendant, therefore, and the Jones case, therefore, does not apply retroactively in the Ninth Circuit. Now we have three Supreme Court of California cases, the first arising under the Indian Child Welfare Act. The minor in People v. W.B. faced delinquency proceedings under Section 602 of the Welfare and Institutions Code, and the issue arose whether the Indian Child Welfare Act applies to such cases. The minor argued that state legislation had expanded the ICWA to delinquency proceedings under Section 602, and that position was supported by some intermediate appellate precedent. The California Supreme Court disagreed, however, holding that Section 602 proceedings presumptively involve a placement based on the ward's delinquent conduct rather than bad conditions in the home, and are thus not subject to ICWA's notice provisions. According to the unanimous court, California law requires the court to inquire about a child's Indian status at the outset of all juvenile proceedings, but the ICWA's additional procedures of notice are not required in most delinquency cases. Instead, a delinquency court must ensure that notice is given and other ICWA procedures are complied with only in narrow circumstances, where the court's exercising dual status jurisdiction, it's placing an Indian child outside the family home for very narrow status offenses, or it's placing a child outside the family home for reasons other than the violation of law and because of conditions in the home. The court held that it will be presumed that a placement of a Section 602 ward is based on the ward's delinquent conduct rather than conditions in the home, and unless the court announces otherwise, the ICWA will not apply. The court had a death penalty decision. A jury convicted the defendant in People v. Duenas of the first-degree murder of a Los Angeles County Sheriff's deputy. The jury found true the special circumstance allegations that the defendant committed the murder to avoid a lawful arrest, and that he knew or should have known the victim was a peace officer. The unanimous Supreme Court affirmed the death sentence in this case with a relatively brief 35-page opinion. Brief insofar as death cases go. Next, a criminal law decision. The defendant in People v. Turnage was convicted under Penal Code Section 148.1 of one felony count of planting an object near a government building that resembled a bomb, but lacked explosive content, and that caused fear and disruption when discovered. A completely different statute, Section 11418.1, makes it only a misdemeanor to place any false or facsimile of a weapon of mass destruction with the intent to cause fear in others. And a violation of this statute can be a felony only on the additional showing that the placement caused sustained fear. The Court of Appeal had concluded there was no rational basis for the distinction between these two crimes under an equal protection analysis, and therefore reduced the defendant's felony conviction to a misdemeanor. The Supreme Court of California unanimously reversed. According to the court, the legislature might reasonably have concluded, under a rational basis analysis, that fake bombs are much more likely to be recognized as a dangerous device and to cause more serious and widespread fear than a fake WMD. And because of this possible reasonable difference, there was no equal protection violation in punishing the fake bomb more seriously than a fake WMD. And that's the Kelso Report for today. Have a great day in the law.